He is one of the best students that I've ever had. Although my grades aren't in yet, so I don't know.
Good afternoon, everyone. As Dean of Widener University School of Law, I want to warmly welcome everyone to our annual celebration of the inspiring life of Dr. Martin Luther King, Jr. Dr. King, perhaps more than any other recent American leader, dedicated his life to moving our great nation closer to the ideal of racial justice. To put this point in words that resonate with our current political culture, Dr. King was an authentic agent of change with the experience and knowledge to make change effective. Of course, we have not yet completed Dr. King's essential work, but his inspiring legacy continues to stand as a testimony to the conviction that no one can be free and enjoy the fruits of freedom until we all are free. This commitment to the dignity of all members of humanity is continually tested and challenged, and we can pay Dr. King's memory no greater honor than continuing his unfinished pursuit of justice by applying his convictions to current challenges. This year's topic is, what would Dr. King say and do regarding the Jena 6 incident? Today, we are fortunate to have three distinguished speakers to provide insight into the nature of this incident, especially its legal and social dimensions. In no particular order, our panelists are Mr. Jerome Wyatt Mondesire, President of the NAACP of Philadelphia, and I hope I pronounced his last name correctly, Mr. Robert Listenby, Chief of the Juvenile Unit of the Defenders Association of Philadelphia, and Mr. Wadud Ahmad, a former Philadelphia Assistant District Attorney who is currently in private practice, and he is also, I believe, a 2003 graduate of this fine institution. Gentlemen, welcome. Before I turn the program over to Professor Lipkin, please join me in thanking him and the members of the Diversity and Accommodation Committee. And if those members are present, would you please stand to be recognized? And especially thank student and committee member Charles Gibbs, who was instrumental in planning the special program. Charles, where are you? I would also at this time like to thank the members of the press who are here with us today, particularly WHYY TV and the News Journal for covering this special event. There may be other members of the media who are also here. I thank you for coming. Welcome, and at this time, I would like to bring to the podium Professor Robert Lipkin.
Welcome. I would like to just give a brief background of the annual event, which has been to commemorate the life of Dr. Martin Luther King. And from my point of view, I think it's very important to stress what his distinctive contribution was. It won't take more than 3 or 4 hours to do this, so you needn't worry. But I can contrast Dr. King with probably all of us. All of us are ethical partialists. We all believe in helping the poor and in contributing charity and doing the right thing. But we also have a pronounced sense of our own self-interest. And we also realize that people can't do People can't change things overnight. And so our resources are spent minimally to improve the world, but for the most part, to improve ourselves. After all, BMWs are really cool. Dr. King, in my view, was totally antithetical to that. He was clearly an ethical holist. He believed that his life could not be meaningful until everyone else's life was. And let me quote. He said, "I can never be what I ought to be until you are what you ought to be. And you can never be what you ought to be until I am what I ought to be." These words of interconnectedness really goes back to ancient times and biblical times. Dr. King answered the question of whether or not he was his brother and sister's keeper by saying, absolutely. He couldn't imagine the kind of separation that perhaps we have here today. His concern about racism and poverty and war was fundamental. And essentially, he was opposed to racism because it really said, you can't be like me. He was opposed to poverty because it said, you aren't like me. And he opposed war because any of the interconnectedness between and among the various peoples of the world was completely shattered. Now, I just want to say that I actually participated in a peace demonstration in 1967 with Dr. King. I was 1 year old at the time, and it was from Central Park to the UN. And Dr. King, not only because of that march, but because of who he was a person who I admired perhaps more than any other political leader or social leader that were around when I was growing up. One of the things we want to do with this event is to try to make his life clear, or at least more clear to our students. Obviously, many of our students were born after his death, and therefore they related to him in the same way I related to Lincoln when I was growing up. He was, and I didn't know him, by the way. He was a very important person who I admired, but he wasn't vivid and real to me. Martin Luther King was vivid and real to me, and what I hope is that we can convey part of the reality to our students. He's not just a man in a book. He was a person that perhaps contributed to more of the fundamental values of this country than any other leader. At this time, I would like to express a kind of departure from what we usually do. This is the first time that we are going to have, as part of the program, a student, Mr. Charles Gibbs, who worked passionately and dedicatedly and exhaustively to arrange this panel, and the topic was suggested forcefully and persuasively by him. It is true that his presence on the panel is partly a result that he threatened to take every course I teach if I didn't put him on the panel. But actually, it wasn't it wasn't much of a threat because I welcomed him. He's a remarkable young man, and let me introduce Mr. Charles Gibbs.
Good afternoon. It's really a distinct honor and pleasure to be here. As you all know, grades come out soon, so I hope that Professor Lipkin expressed his admiration for me and my grade. In April 1963, as he sat in a cell in Birmingham City Jail, Dr. King said that injustice anywhere is a threat to justice everywhere. As attorneys, as future attorneys, as law students, we are given the mantle of being the protectors of justice. We have an obligation, indeed a moral responsibility, to make sure that justice prevails, that our country, that this country that we live in and that we abide in and that we will work to make better, continues to be one country, one nation, under God, with liberty and justice for all. I would submit to you today that justice was not in Jenner, Louisiana a few years ago. I would submit to you today that those 6 young men who got into a schoolyard fight, who I will admit were no perfect citizens of Jenner, Louisiana, they didn't see justice. Maybe now today, after our nation focused its immense attention, and after dollars started pouring into Jenner, Louisiana, and after civil rights leaders from all around the nation, including our own president of the Philadelphia and Pennsylvania NAACP, took action. Maybe they got justice now. But the sad fact of the matter remains, as Dr. King, I'm certain, would say, justice delayed is justice denied. So what do we do from here? We can talk about Jenner, Louisiana. We can talk about the injustices that happen. We can acknowledge that justice is not denied solely based upon the color of one's skin today, as it was in 1963, but it is denied based upon the fact that someone might not have the adequate money to get private counsel. There's social justice is not blind. We have an obligation, a responsibility. I took my work with this committee seriously, of putting the blinders on justice so that no matter if you're white or black, rich or poor, Indian, Native American, African American, or Middle Eastern, you will have justice in our country, because that is the bedrock of our foundation, the bedrock of freedom. So I hope that you enjoy this panel. The entire committee worked very hard. A lot of emails back and forth between professors and myself, but I think this was a great panel, and these people can talk expansively about making sure that as future attorneys, we ensure that justice continues to be the bedrock of our foundation, because without it, we will fail as a nation. Thank you.
Our first speaker is Jerome Mondesai.
Good afternoon. Wake up a little bit. Good afternoon. It's much better, much better. I asked to go first because I had to have my son drive me out here today because I had back surgery yesterday. It's my son Joey. He's a freshman in Morehouse. Want to stand up, Joey? So I figured if I go first, that way I can sit down longest. Thanks very much to the Dean, Dean Ammons, and to Professor Lipkin, and to my buddy Charlie Gibbs, who's a friend of my daughter's, who is a lawyer back in Philadelphia. She's a public defender. And when you asked me to speak, Professor Lipkin and Charles, I was honored because to get a chance to talk to the future lawyers of our society, especially in Philadelphia, always encourages me, because hopefully a little bit of what we talk about today you will take out into the real world. And so much of what's wrong with our society is in your hands as lawyers or as future lawyers, because too many of you become the legislators who make the bad laws, too many of you become the horrible judges who enforce the horrible laws, and even more of you become prosecutors who actually put people in jail when they don't belong, where they don't deserve to be. So the conversation with you is a good one, I hope, because hopefully the thoughts and the ideas that my fellow panelists and Professor Lipkin and others will share with you maybe will stay with you when you go out into the real world. The great tragedy about what's happening today in our society is that so many of us think that the civil rights struggle, the human justice struggle is really over. You don't really care about it. Dr. King actually, on his birthday, when it is celebrated officially in just a few days, will have been dead longer than he was alive. I just want to repeat that. Dr. King will have been dead in 2008 longer than he was actually walking on this planet. Most of you have no idea, like Professor Lipkin said, what it was like during the civil rights struggle. You have no concept. It's even more disturbing for a person like me who's a civil rights activist in the state of Pennsylvania, because when I speak to high school students in Philadelphia, most of the time they're predominantly African American, and I'll reach into my pocket and actually pull out money, $20, $50 bill, and offer the high school students money if they can tell me what the initials of the NAACP stand for. Most of the time I'm able to take my money home. It's both funny and also frightening, because our society is not passing on the lessons that we learned just 40 years ago, just 30 years ago. So the Jenna 6 case is a perfect way to talk to you young people, especially you young attorneys to be, about the civil rights struggle that is in your time and in your place. I remember, of course, the Philadelphia, Mississippi case of the 3 civil rights workers who died and were buried in an earthen dam. Anybody want to give me their names? Not you, Professor Bell. I mean, Ammons. But they were Cheney, Schwerner, and Goodman. And that was a seminal civil rights case, civil rights incident involving young people who were not jailed, they were killed for their belief in improving the American system back in 1964 in a place called Philadelphia, Mississippi. So Jenna 6 has become the 21st century Philadelphia, Mississippi case for all the young people you saw demonstrating down in Jena, Louisiana back in September, and the students, I hope some of them were at the Widener University campus. I know we had some at Temple, we had some at Penn, and some of the other campuses in the Philadelphia area. More than 500,000 students across this country demonstrated about the Jena 6 case, because finally the current civil rights struggle had a face that they could recognize. It had names like Michael Bell and others that they could understand and relate to. So when Charlie Gibbs and Professor Lipkin asked me to come and talk to you about it, I jumped at the opportunity, because too often in today's society, the civil rights struggle, the human rights struggle gets subsumed by what kind of video game are we going to buy this week? How are we going to pay our mortgage? What's the price of oil? And who's the latest guest on Oprah? And then finally, what's happening with Britney Spears? We're not having conversations in our media and in our classrooms and around the water cooler like we did 40 years ago when Martin Luther King walked this planet. I'm not an attorney. I'm a journalist, so I won't try to dissect the Jena 6 case from a legal point of view, or to try to walk through all the various aspects of prosecutorial discretion and whether the judges ruled correctly and so forth. I want to talk about the inequality in our criminal justice system that is reflected by the Jena 6 case. Because the Jena 6 case is really the big pus sore on a national disgrace. Even before this country was recognized as a nation, race in America has been synonymous with inequality. The very Constitution of this country recognizes the different expectations blacks and whites can have at the ballot box in the so-called infamous 3/5 compromise for counting white citizens and black slaves for the purpose of representation in the U.S. House of Representatives. We make up just 13% of the American population, yet we comprise 41% of the prison population. And while we constitute just 15% of the drug users in this country, 63% of the drug offenders in this nation sent to prison are African American. It's not that African Americans are more likely to use drugs. In fact, the National Household Survey on Drug Abuse says that whites make up about 2% of the illegal drug, 72% of America's illegal drug users, while blacks represent 15%. But we are more likely to be caught and more likely to be sent to prison. Criminal behavior of any kind, of course, should be prosecuted whenever it occurs. But easing the poverty that afflicts too many non-white communities would have a profound effect on reducing the crime within them. That will take more jobs and better education to qualify for those jobs. on the death penalty, however, is probably the clearest example of where we can see the inequality in our criminal justice system. And right now, the Supreme Court, as all of you know, because I know all of you read the paper 2 days ago, right? The Supreme Court is hearing a case on what? You got it. You passed this course. And so when we look at the death penalty, we find that blacks and whites are murdered in about the equal numbers each year, says the anti-death penalty organization called Amnesty International. However, the killers of white people are more likely to be executed than the killers of black people, says Amnesty International just a few years ago. 80% of the 845 people executed since the United States resumed executions in 1977 were put to death for killing whites. A disproportionate number of those were black, and many were convicted by juries but had absolutely no black members. Blacks make up just 13% of the population, as I said a few minutes ago, but 41% of those on death row and 35% of those executed between 1977 and 2001 were African American, according to the U.S. Justice Department. And while we constitute a very small number of the people who are set aside, we are the ones who are being sent to death. Let's talk about Pennsylvania for a second, a state that I'm most familiar with. And right now in Philadelphia, we have 9,000 inmates in our jail system. 9,000. Our police commissioner who just stepped down, the recent police commissioner, Sylvester Johnson, was often criticized as somebody who wasn't tough enough on crime. They locked up more than 7,000 people in the city every year on various crimes. The capacity for our Philadelphia prison system is 6,500. In Pennsylvania, our capacity is right now is over 45,000 people who are locked up in jail, 100% of 110% of capacity. Our population in our prisons in Pennsylvania is growing by 125 a month, and we will run out of space. We'll run out of space in 2012. There are 580,000 African-American men in federal state custody on any given day in the year 2008. And only 40,000 black men will graduate from college in any given year in this country. The disparities are just overwhelming. And they're overwhelming to such a point that a 1999 study found that 52% of the black men who had dropped out of high school would have a criminal history by the time they reached their early 30s. Let me close by telling you a story also, because we have a prison branch at Graterford Prison, which is one of our maximum institutions, maximum penalty incarceration units in Pennsylvania. And in Graterford Prison, where I speak from time to time, we've had a prison branch of the NAACP since the 1970s. I was just there a couple of weeks ago to a program because we are finding that of the 40,000 or so folks who are locked up behind walls in Pennsylvania, roughly 15,000, 18,000 are coming out every year, and the majority of them are coming back to Pennsylvania. So this program that we held a few weeks ago was all about reentry programs into the city of Philadelphia, a program which our new mayor, Michael Nutter, has expressed a great interest in. And when I was at the prison talking to the men about publishing some of their poetry in our newspaper and also finding jobs for them when they come out, the young man who who ran the program was a very tall, statuesque man, like Brother Wadood here, and had a deep baritone voice, and was a great MC. And he held the room totally in trance. He was about 200 people there. And as he spoke and talked about the conditions and some of the things that the men wanted to accomplish, I was really taken aback by his performance. And you're never supposed to ask when you're inside the jail, what did you do and why are you here? But he was such an eloquent speaker that I broke the rules, and when we got to the break period where you could go and have a chance to see the men quietly on the side, I did ask him. And he told me he was doing 30 years for bank robbery. And then as we talked some more and he found out a little bit about my history, he found out that I grew up in Harlem on 125th Street and that my father had been a Garveyite. That's Marcus Garvey for you. And also that I had seen Malcolm X speak in front of many of the bookstores and gathering hotspots in Harlem back in the 1960s. He said, oh, that there would be somebody further back in the prison who didn't come to the program who would get a chance to talk to me about Harlem, and especially the Harlem of the 1960s, that I would love to meet him. And so we went back to meet this man. And he was near the physical workout room, but the conditions of the Greater Fit workout room are pretty dismal. The barbells are rusted and the weights look pretty sad, but he was working out. And as we talked some more about the 60s, and we talked about the visit of Castro to Harlem back in 1959, and Adam Clayton Powell, who was a famous congressman back in Harlem, the older man introduced me, and he said, the man who was the MC, you know, that's my son. That's my son. And then we talked some more, and he wanted some more stories, and he especially wanted to hear about Malcolm X, because obviously he'd seen the movie with Denzel Washington. And Malcolm X used to speak right in front of my apartment building. And those of you who've seen the movie where he's standing in front of the jewelry store and giving one of his really tough speeches about, you know, you didn't land on Plymouth Rock, Plymouth Rock landed on you. That was in front of my building, and I didn't see that particular speech, but from time to time I would see Malcolm out there when I was a youngster, about 10 or 12 years old. He wanted me to go meet somebody else, somebody who was not part of the program, didn't want to be part of any kind of Black History program or learning what to do when you get out, because he wasn't ever going to get out. He had gone back in jail after a second murder, and we went back and talked to him after I got special permission, though, from the guards, because this man wasn't being held in solitary confinement, but he was being held in something just under that because of some rule or infraction that he had violated. And to make the story short, we got to talking with him, and he didn't particularly like me per se, but he liked some of the stories, especially the war stories about Harlem and the Black Panthers, and some of the other stories of characters who were in Harlem, like I lived just a few blocks from the Apollo. So it was a chance for him to kind of relive a younger moment in his life, and he liked just hearing the names mentioned. And it turned out that the middle-aged man, this was his father. So the point of the story is a simple one here. We have allowed a generation to go inside our prison system and to stay in our prison system to the point where it is becoming a way of life in the Black community. When I was Joey's age, going to prison was an embarrassment and a sign of shame. And today, in the Beanie Siegel generation, in the 50 Cent generation, in the generation where hip-hop has become a way of celebrating the most ghetto, fabulous, self-destructive behavior I've ever seen in my life, going to prison has become a way of life, almost a rite of passage. That is what we have allowed to happen in this country. And so my simple admonition to you young attorneys, take what you've learned in this institution, use what you gained from Professor Lipkin and Dean Ammons and all the other teachers you have here. Do something with it. If you don't practice defense law, which I wish you would, of course, if you do something with it to do some kind of work to bring some more justice and fairness and equity to our system. The question is, what would Martin Luther King be doing about Jena 6? It's a simple one to answer, what I told HYY a few minutes ago. He'd be talking about free to Jena 6. Because obviously when you look at the history of what happened, it's right there in your program. It is an outrageous case of injustice. But it's bigger than Jena 6. Jena 6 is just a way of describing a national problem in a single moment that the average person can grasp. We have a serious problem in our criminal justice system. If we don't do something about it, it will affect us all in the worst ways possible. God bless you and thank you.
Mr. Listenby?
Good afternoon, everybody. It is indeed a pleasure and honor to be here on this special occasion to speak about Dr. Martin Luther King. He is, of course, for my generation, both a role model and an inspirational speaker, a leader, and someone that I and many others pattern ourselves after. It's a pleasure also to be here with this distinguished panel. I'm usually used to seeing Mr. Mondesire on TV, so to be sitting next to him here is indeed an honor. Dean Ammons, pleasure to be here and meet you. Professor Lipkins, after many emails, pleasure to actually see you in person. And Mr. Gibbs, you're working for one of the finest lawyers I've ever worked with, Judge Simmons, who worked in the juvenile unit for quite a while, and we were very pleased to have her work with us. I've been very curious since this whole phenomenon concerning the Gina 6 started, because my 12-year-old daughter, when it started, she was 12, she's now 13, came to me and said, "Daddy, we have to do something about this." And it's the first case that's occurred during all the time that she's been with us since birth, that she's actually had such a strong interest in what was happening throughout the nation. She wanted to wear an armband. She wanted to demonstrate at her junior high school. You all need to know that this case has touched the lives of this entire generation that you are a part of, and that it is leaving a mark. Right now, the news seems to be dying down a little bit, but there's still a lot of concerns that she has about why. She said, "Why, Daddy? Why did they lock those boys up? Why are they still in jail? What can you do about it, Daddy?" She asked me because I'm a public defender. And as I read through the materials and saw that Blaine Williams, who was the public defender who first handled Michael Bell's case, has been spoken about in somewhat disparaging fashion, I wanted to talk to you briefly about two basic ideas and about the role of public defenders. The two basic ideas are as follows. In Dr. King's many speeches, one of the things he says that I hold on to dearly is that the moral arc of the universe bends towards justice. The moral arc of the universe bends towards justice. And so as I go through the many battles representing children in the city and county of Philadelphia, speaking on their behalf throughout the state of Pennsylvania, working on cases and matters throughout the nation, I always keep in mind that no matter how difficult it might seem, no matter what injustices we may be facing, that the moral arc of the universe does indeed bend towards justice, and that if I and others that I'm working with are able to do so very diligently, that justice will ultimately be served. The second idea is an idea that came from Mahatma Gandhi, a person upon whom Martin Luther King based many of his nonviolent practices. Mahatma Gandhi said, "We must become the change that we want to see in the world. We must become the change we want to see in the world. We must become the change we want to see in the world." So I have committed my life to being the change that I want to see in the world in this very narrow area of juvenile justice practice. I'd like to give you an example. I'm going to step away from the podium for just a moment to tell you what people first told me about the work that I was doing. When I first started off as a public defender, I had a young intern come to me from one of the colleges here in Pennsylvania. That young intern told me that he'd been in a criminal justice class, and that in that criminal justice class, his professor told him that if you had a public defender, you were probably going to be represented in the following fashion. You would meet your public defender in the back of the courtroom like this, and as you walk towards the front of the courtroom, you would introduce yourself to the public defender. "My name is Johnny B. Good." The public defender would ask you, what did you want to do, plead or go to trial? He would tell you what the charges were. He would ask you if you had any witnesses. He would tell you that the prosecutor had made an offer. And by the time you got close to the front of the room and about to sit down at the table, he would tell you that the odds were against you because he or she had not had an opportunity to properly prepare the case. That is what he told me, and quite frankly, we've done a survey in our office of people in the city and county of Philadelphia, just a little random survey, and that is what the general public thinks of public defenders. I'm here to tell you that in our practice in Philadelphia, we have the very highest standards for practice, that we believe that we, on any given day, can do something that will change the life of a child, and that every possible avenue, every possible resource that is available to adults who are trying homicide cases is available to us as juvenile defenders, that indeed, according to the people who assess these kinds of things, in our office, one of the very best lawyers in the office is also in the juvenile unit and is a specialist who's been trying cases there for at least the last 15 to 20 years. So in spite of what the general perception is of the work that we do, and the general perception of what Mr. Blaine Williams did down in Jena, Louisiana, I'm here to tell you that there is a practice that is modeled on the highest standards of excellence, and ethical practice, and that if you at any time decide to aspire to do this kind of work, that you can look forward to finding places both here in the city and county of Philadelphia and other places throughout the nation where public defenders do indeed have high aspirations, high standards, and good results as they go in the courtroom. As I look at this case and look at the issue of prosecutorial misconduct, ethical standards of the prosecutor, I'm looking at it from the point of view of a defense attorney. For the juvenile practice, the American Council of Chief Defenders has set a standard saying that we should have an average of 250 cases a year. I know for a fact that in Louisiana, because of studies that have been done there, one that I participated in, that many juvenile defenders have average caseloads of 800 cases a year. In addition, many of them also carry adult caseloads, and between their combined caseloads have caseloads of over 1,000 cases per year. This is a study that I participated in 2001 that was updated 2 years ago. So the update says that this was the current practice. I don't know if it was in Gina, Louisiana. However, if that is the number of cases you have, it is not possible for you to devote to those particular cases all the time, energy, and resources that are necessary to provide the standard of excellence that we aspire to as public defenders. I also know that in many places, including Louisiana, that the culture calls for plea bargaining, that in some jurisdictions, 90% of the cases are pled out. In a culture where a plea is the standard, it is very difficult for a lawyer to rise above the practice and the culture and aspire to the basic standard that we have in this country, which is an adversarial system. So you will find this kind of a practice in some places in Louisiana, but I am here to tell you today that it is not just in Louisiana that you find these practices. The National Juvenile Defender Center, njdc.org, has been conducting evaluations across the nation. And those evaluations have established in at least 16 or 17 states that the kind of practice I just described for Gina, Louisiana, or for Louisiana also goes on. Even here in Pennsylvania, if you go up to Luzerne County, you will find that the majority of children in that county waive the right to counsel and pursue their cases, many of them ending up in placement, based upon their own judgments without the benefit of counsel, and because they've waived the right to counsel. But you don't have to go that far. You can go over to Montgomery County, which is within a stone's throw of where we're standing, and you will find that in that county, there are 2 lawyers handling juvenile cases with caseloads of a total of about 3,000 to 4,000 cases. So you don't have to go to Louisiana to find practices that are questionable, to find standards that are inappropriate. You can go over to a neighboring county where we live. You can stay in your own state. And you can find that if you are represented by somebody who does not have the time to prepare, that you're not going to get the kind of justice that Dr. King aspired for all of us to have. In addition to caseloads and ethical and caseload standards and pleas, when you get to court, you need to have all the tools that are involved. I was looking at the cases as they went through the system, looking at Michael Bell's case to begin with. When he had the jury selection process, there was a question about whether he should have asked for or pursued a change of venue. I didn't see anywhere in the literature that I read that there was a pursuit of a change of venue. But as an aggressive lawyer, I would hope that any of you practicing, looking at a case like this, would at least file a motion and pursue the motion, even if it were denied. During the jury selection process, I didn't see that there were any Batson challenges or any other kinds of challenges to the manner in which the jury pool was configured. But if you have that kind of problem, a good lawyer with proper resources can challenge it. In looking at the situation regarding the case being tried in adult court, here in our county, there are motions that you can file to have the case decertified and sent back to juvenile court. Ultimately, the second lawyers that took over the case actually did that and had his case sent back to juvenile court. But why it wasn't done by the first lawyer, Blaine Williams, I don't know. But if you are going to pursue this kind of practice in order to address the issue of unfairness, in order to address the issue of misuse of prosecutorial discretion, in order to address the issue of perhaps improper ethical practices by overcharging on the part of the prosecutor. What you can do is you can pursue a strategy to have the case decertified and sent back to juvenile court. Now, one of the problems in pursuing a decertification motion is that you need experts. You need a psychologist, you need a psychiatrist, you need perhaps a neurologist if the child had fallen and injured his head at any point in time in his life. You might need an education specialist if the child had educational disabilities or had been a part of a special education program and had an individual education plan. And if you can't hire those kinds of experts, then you're not going to be able to pursue your motion for decertification in an effective manner. When we faced this issue in Philadelphia County, my boss, Ellen Greenling, told City Council, either you give us the money so that every single child who is certified to adult court or direct file to adult court, every single child, and we have over 400, we had over 400 in the last year, we have to have enough money so that we can pursue a psychological evaluation with our own psychologist for every single child. And if you don't give us the money, enough money to do it and do it right, we're not going to do it. If you don't give us enough money to pursue every expert that we need in order to represent these children, we're not going to do it. And so City Council mulled the issue over and ultimately made a decision that they would give us the money we needed to represent these children. And now every single child that needs these experts gets an expert so that the job can be done well. And as a result, a substantial number, over half of the children who are sent into adult court in Philadelphia County actually come back to juvenile court because the decertification motion is litigated. I don't want to get too far and too deep into all of the precise legal issues because there are the overarching issues that we ought to address. But I want you to know that as you look at situations, you see that these boys, all 6 of them, were in jail. Now, in the juvenile justice system, we don't have a bail system here in Pennsylvania. In places like Florida and Louisiana, you have to pay bail to get out. In this state, you are allowed to be released. The general assumption is that you will be released to your parents unless there's a likelihood that you're going to reoffend or that you're going to abscond. But in Louisiana, it was different. But even where there is a difference, you have a right to make a motion for a bail reduction, and you have a right to file a petition for habeas corpus if you believe that the bail reduction has been improperly denied. So again, good lawyering can overcome a lot of improper behavior on the part of the prosecutors. But you as lawyers are going to have to take it in your heart and have the compassion, the aggressiveness, the determination, and the skill to pursue these avenues if you're going to be able to properly represent children who are facing the kinds of difficulties that these young men were facing down in Louisiana. I see that the children have remained in custody, and they're all out of custody now, but they were in custody for long periods of time. All kinds of options are available to try and get bail reduced, to try and get options available in terms of different types of collateral, or to try and get the judges to reconsider their decisions. I just didn't see that some of that was done. I'm not going to say it's bad lawyering because I wasn't there. And what I know as a lawyer is until you can examine the case file and look at all the basic options that are facing a particular client, you don't know what options are really viable. So I'm not going to presume that bad lawyering is there on any count. But I'm going to tell you that if you are going to pursue these kinds of avenues, and I do encourage you to do so, that these are the kinds of things that you ought to consider. Now, in modern society, as Mr. Mondesire was saying, we have disproportionate minority contact and confinement in American society. In Pennsylvania, 70 to 80% of the young people who are confined are children of color, Hispanic and African American primarily. I want to tell you that it's possible to change this kind of result. I don't want you to go away from this talk that I'm having with you and that we're having with you feeling that these are the kinds of problems that can't be addressed. The prosecutors can change it in conjunction with public defenders and court administration in Pennsylvania and other places by having diversion programs. In Philadelphia County, diversions have gone up from 69 4 years ago to 600 at the opening of the door. The prosecutors have decided that they want to provide more consent decrees and have increased them from about 400 to almost 1,000 a year, thereby diverting kids out of the system so they won't get long-term records or go deeper into the system. There are 4 or 5 other programs, but one of the primary ones that the prosecutors began using in Philadelphia County recently in conjunction with the public defenders was a diversion court. If you have a felony drug charge, in Philadelphia County, you can go to drug treatment court if you have a drug problem, and you can enter a plea, get treatment, and after 6 months of treatment, if you complete it, usually it takes longer, but once you complete it, a year later, once you complete it, your case will be discharged, and a year later, your record will be expunged. Felony drug cases. Felony drug cases. In addition, we are now, with the benefit of the MacArthur Foundation, considering a new type of court, something called a court that's designed to address violations of probation. In that court, if you have a violation of a probation, instead of going deep into placement, we're going to look at the possibility of having you get a weekend respite or a community respite or be placed for 30 days or 60 days or 90 days or anything different than going in for 9 to 12 months. This kind of graduated sanctions court is a novelty, but with the benefit and help of the MacArthur Foundation, and in particular their Disproportionate Minority Contact Action Network, we are going to be receiving over $100,000 as of yesterday to develop this kind of an option so that we can reduce disproportionate minority contact. Finally, there's something that you can do even while you're in law school. And you can do it in this county or any other county that you work in. Pennsylvania is one of those unique states where you can actually have records expunged. 5 years after your case is discharged in juvenile court, your record, your fingerprints, your photograph, and all the documents related to your case can be expunged. The problem we have in Pennsylvania is that we don't have enough people to file those expungements. And all the counties across the Commonwealth, people are trying to get their records expunged. If you set up an expungement clinic, even at this law school, you could help thousands of children get their records expunged. For the most part, these are pro forma kinds of matters. You go into court, the judge signs off on them. Even where there are lengthy hearings, these are hearings that you could do in conjunction with lawyers that are out there practicing. So there are lots of things you can do, even now, or as you go forward in your practice, if you decide to take a corporate law practice. And I don't want to demean corporate law practicing. I thought about doing that initially myself. But you can do pro bono work from your firm and help out with some of these kinds of things. So again, there are lots of things, and I want to hope to get a chance to answer any specific questions you have, but there are lots of things that you can do and lots of things that can be done to address the kinds of problems that have been raised by the GINA 6, and specifically you can do them while you're still here in law school. Again, we must become the change that we want to see in the world because nobody else is going to become that change. Nobody else is going to do all this. Those of you who are sitting here and sitting in law schools across the country are going to be the ones who do it. And if you, like me, want to hold on to something, remember what Dr. King said when he said that the moral arc of the universe bends towards justice. Thank you.
Thank you very much. Before we hear our last speaker, I want to invite you all to ask questions at the end and then attend a reception. Mr. Ahmad.
Thank you. I'll actually try to be brief. Yesterday, I completed a 3-day jury trial. Right? The basic facts. These are basic facts. My guy, my client, he is observed on a videotape with a handgun in Germantown, the Germantown section of Philadelphia, on Germantown Avenue, and he's discharging that firearm. And he's right outside of a community center that just so happened to be holding a community meeting where 2 police officers were. Police officers hear the gunshots. They open the door and they see my guy 15 feet away firing a handgun at 2 people running away, who eventually jump over a fence and leave. Right? They don't kill my guy. That's why we had a trial. They tackle him down, take the handgun, and they find out that he also had a gunshot wound to his leg. Those are the basic facts. Right? My guy has a record. He has some convictions, and as a result, is not authorized to have a handgun at all. And he was charged subsequently with attempted murder, ag assault, possession of instrument of crime, reckless endangerment of another person, as well as gun charges, and in particular, the one that was really harmful, 6105, which says that a convicted felon can't have a gun, right? Now, the verdict came back yesterday, and the verdict was, what was the verdict? What do you think? Of what? Of everything. Who thinks guilty of everything? Raise your hands high with confidence. Who thinks not guilty? Wow, so that's what it's like as a professor when you ask for a show of hands, and that's what it was. That's what it was. All right, trying to straddle the fence. All right, not guilty of attempted murder, not guilty of aggravated assault, not guilty of reckless endangerment of another person, not guilty of possession of an instrument of crime. Guilty of the handgun, and I actually talked to one of the jurors, and she told me, I actually saw her in the gym afterwards, and she said that the only reason why we got him for the gun, everyone wanted not guilty in everything, but the one alternate that replaced the juror that got sick, he said that if you pause that video, I'm pretty sure I saw him pulling that gun out of his waist. And, you know, if we go back and see that, then I don't want to hang this jury. You know, let's split the baby and we'll hit him for the gun. She tells me that I tell my fellow jurors, okay, because if he gets hit with a gun, my friend of mine had a gun on the street and all he got was community service, so I'll go along with that. They got him with a gun because of that stupid alternate. But anyway, guilty on the gun. Now, this is the reason why we were successful. The reason why we were successful is because I had to confront the jurors with reality, with their own biases, with racism, right? My guy, African American, young, 23, stocky, tattoos on his neck. There's not a humble bone in his body. No matter how many times I gave him the lecture in his cell about you got to soften up. I told him the first thing, when you come out in that courtroom and you're sitting down, I want you to stand, I want you to be humble, I want you to say, hello, ladies and gentlemen. When he comes out, he comes out like a thug, he sits like a thug, his posture's like a thug, and then when he first meets the jurors and stands, what's up? So I leaned over to him and I rubbed his back and I whispered in his ear and I had a smile on my face. I said, the only reason why I'm doing this right now is because I want the jurors to think you're a human being. Okay? Because right now you look like a motherfucking animal, and if you do that shit again, I'm gonna beat you. Okay? But that's reality. It's reality. Reality. Always be a thinker. Because if you're a thinker, it will allow you to see obvious things that oftentimes you can't see, like racism, our own biases, our own imperfections in the way we view the world. So, in my closing argument, the thing of my case was the self-defense. He got shot because they shot him. The DA says that my guy shot himself. Okay? And in my opening, really shortly, I said, listen, the blessing that occurred to my guy was, well, two. One, that the officers didn't murder him. Well, they didn't kill him, it wouldn't have been murder, it would have been justified. And two, that he got shot. Right? Because had he not gotten shot, and that's what I told him in my opening, there would be no way I could convince you that he's telling the truth. Couldn't do it. Because you're not going to give him the benefit of the doubt. Because he looks guilty based on how you view people. Right? And so in closing, I sum that up. And I had my guy sitting in the courtroom with a turtleneck on the whole time to cover his tattoo. But in order to drive home the point, when in my closing argument, I go over to him and I pull his tattoo down to expose to him the trick that I had to play on them to get them to look at my guy fairly, and then shame on them, right? Boom, it hit home. Some obviously it was theater, but also it was truth. So then I got them to now look at my guy with honest eyes, hopefully. So, I come from the DA's office, right? I'm a defense lawyer now. There's a culture, and looking at the Jenna 6 case, I think it's important for us to look at the culture of prosecution. The best thing that's happened to me, in terms of as I progress as a lawyer, is now seeing defense side. And I made a suggestion to one of the chiefs at the DA's office. I said, you know what we need to do? And I'm going to tell Lynn this too. Well, or whoever heard it when she leaves, her predecessor. There needs to be an exchange program for the young lawyers. When you go into MC, the municipal court unit as young DA, you need to spend 6 months in the PD's office, in the public defender's office. And public defenders need to spend 6 months in the DA's office. Because then, your job would not become your religion. Don't make your job your religion. What happens because I was an older student, when I went to night classes here, I had lived a little bit. I didn't march with Dr. King, but I lived a little. And so all the young lawyers who were in my class, 24, 25, first job, glad to be in the DA's office, had on their blue suit and had their flag nice and shined, and were ready to just go prosecute the world. My background, I was an artist. I made a decision to go to law school on a train in Austria. Okay? So I looked at the world a little different. Okay? And so when, so I wasn't gun-ho for gun-ho's sake. And when you're really not a critical thinker and you join your tribe, whether it's Democrat, Republican, right? Crip blood, public defender, prosecutor, you get blinders on. And in the DA's office, the culture is prosecute, prosecute. You can't show that you're weak. Right? You can't show that you're weak. And so what happens is, often over prosecution. And then, for example, so I start off in the MC unit, I progress to the juvenile unit, spent about 2 weeks in the felony waivers unit, and then they hand-selected me, because I was winning cases, to go to the family violence unit. And then they usually pick you out of there to go to homicide. Family violence is the most difficult unit because it's hard to prove a rape. Our unit had a 30% win ratio. I had an 80% win ratio. Okay? Because I understood people. I could convince the young victims often who were to show up, because half the battle was getting your victim to show up. And to get them to be convincing. But I'll tell you one story. I was given a file. This is when I first get to the unit. And it was slated for a jury. I was given a file on a Friday. And I was instructed to look at the file, pick a jury on a Monday. This was going to be my first jury. Look at the file. The file was thick. It had been around the office for a long time. DAs had come and gone and had written all types of notes. It was a rape case. A woman says that her ex-husband kicks the door in, throws her to the ground, forcibly rapes her, and leaves. So I'm looking through, it's okay. She's in North Carolina, we need to fly her in. So I looked at the file and I see there's DNA evidence. And the DNA says that it was someone else's DNA. So I said, damn, that's a problem. You know, now don't get it wrong, listen. I try cases, I love the win, okay? And I love the win is the one that I'm not supposed to win when I say not supposed to in terms of difficulty. Okay? And so I looked at that, that's big challenge number one. Assuming, I'm thinking to myself, that obviously there's an explanation for this because this file has been around this office for a very long time and this rape is hanging over somebody's head. So I said, okay, I'm sure there's an explanation for this. Let me call her before she gets on the plane. Ma'am, I'm looking through the, I have your case, da-da-da-da. There's one little thing in there that I'm gonna have to explain. There's someone else's DNA. What's the situation? She gets very irate with me. I never did anything to nobody else, and he's the only motherfucker, da-da-da-da. Okay. All right. I said, all right, let's do it like this. There are going to be 12 folks in a box, 2 other additional people, which means 14 because they're alternates, and I have to explain to them why someone else's DNA is in you. What should I tell them? I didn't sleep with no one else, it's only him. I said, well, listen, ma'am, I'll tell you this, okay? I said, unless you have some very interesting sexual practices with your husband, which very well may be the case, where you keep other people's DNA on, storage, okay? That's fine. Just let me know that so I can deal with it, right? She goes, sticks to her story. So as I'm flipping through, I see her criminal extract where she had a conviction for a simple assault on this very husband, where she beat him with a brick. Because now I have to deal with the fact that she's, in her story, claiming that she's a pacifist. And then also, too, she was arrested for a homicide, which she beat, but was hit with, I think, possession of an instrument of crime or something like that. So she had some hand possibly in the death of a human being. So she's not that humble. So I said, okay, ma'am, don't get on the plane, I'll call you back. So I go into the office of one of my superiors, and I said, Mr. So-and-so, this case is a little tricky. Did you read the facts? He says, yeah, well, I briefly, I said, DNA thing, da-da-da. He says, okay, well, all right, make an offer. He said, what kind of offer do you think we should make? So I said, we should make the kind of offer that you would take. Whatever that offer is, that's the offer I should make. He said, no, for the case. I say that to say, don't make, does anyone want to be a DA, prosecutor? It's okay. We're going there and pressure because it's important. It's important work. Because if we don't have good folks prosecute, and if we don't have good folks who are police officers, because they're only fishing, this is my problem. Because black folks commit crime, there's no question about it. But if you're only fishing in the black pond, you're only going to catch black fish. Fish in all the ponds, right? I'm not saying I'm fishing in the black pond, because we got to. But also fish in the white pond, too. There's a trap there. And if you're not a thinker, you won't see that. You won't see it, the obvious. How can you, as law students, and as human beings that have come up with this country, think that you don't have a lens of racism? How in hell do we think that is even possible? And so Gen 6 is not about Gen 6. Gen 6 is about Gen 50, all the states. It's not about one town with 6 guys who were acting like jerks. It's not about what they were doing. It's about the concept of everyone being treated equally. Equally. So, if the guy who may have beaten the crap out of someone unjustly and wrongly, it's not about letting him go, but it's about making sure that if you're going to punish him, you punish him the same way you punish someone else. Because he probably still needs to be punished. That's reality. Okay? And so Dr. King, what he would do is what he always did. He would challenge us to act. So folks, you're about to become lawyers. Do not become robots. Don't become robots. Just because your mama told you to, or your dad, because you were brought up a certain way. Be a thinker, so you can live like for real. Right? That's the most difficult thing in the world to do. Be a thinker. Thank you.
I'd like to open up the floor for questions now. Is Connie Sweeney available? Sorry? Oh, okay. I'm just going to turn it over to you. Please raise your hand and try to ask questions that our panelists will have insightful answers.
I don't think I need the mic. I love the idea of the, I'm a former prosecutor. We're recording, so take Okay. I love the idea of there being an exchange between PD's offices and DA's offices. I think that probably the prosecutorial culture is more problematic than the DA's office culture in terms of being narrow-minded, but I think there's a huge benefit, or would be a huge benefit, in prosecutors seeing how PDs live and PDs seeing how prosecutors live. Do you think there's any real prospect, I'm sort of asking on both sides, a prospect of that actually happening? It's tough because a lot of prosecutors don't want to do defense work and a lot of defenders don't want to do prosecutorial work, but I'd love to hear whether you think that's a real prospect.
I think it's very possible if the right DA, okay, is there. Because you have to be open. You have to think outside the box. The rank and file, you know, they won't have a choice if the DA thinks that it's important. And it's one of the things I would spend a lot of time, to be quite frank with you, in the DA's office, telling, and this probably in Mr. Listenby could probably add as well. A lot of times, you know, you come back and you share war stories, and part of the war story is just about the public defender. Oh, they don't, you know, they're blind and all they want to do is smoke weed. What are you talking about? What are you talking about? The person is doing their job. They're doing a job, just like you're doing your job, okay? It's not a personal thing, okay? And so it's not a personal thing, and it's about, I always tell my victims in family violence, I would always tell them that justice is not the result. Because you may, you know, whether the person did it or didn't do it. If they didn't do it, they may get convicted. If they did do it, they may get set free. Justice is the process, and the process has to be fair. So I don't have a problem, as a DA, I don't have a problem with the public defenders who were objecting to everything. Definitely do that. And then you have DAs who get upset with that. And I'm sure the same thing. I'm, you know, on the other side. I left the DA's office to private practice, but you know, I'm sure that there's a similar there's a problem because we're human beings. So you know, you have that tribalism thing that goes on, and if you take that away, and you know, folks start looking at trying to do what is right, then yeah, I mean, I don't think that's a real groundbreaking concept. I don't know if Bob, you're going to...
I'd just like to say, and you have a professor here who can probably answer that question better than I can, because it used to be the practice in Philadelphia County that public defenders, some small number of public defenders and prosecutors actually switched jobs for a while. Lynn Sosnoff, who's a professor here who was back there at that time, I assume, might be able to address that a little more clearly. But it has been a practice. You know, in some cases, like the offices that we have now, people really have become very polarized, and It would be very difficult to do it under the present circumstances. But it all starts with leadership and a good idea. I'm not really sure how it would work in practice, but if you have leaders and good ideas, then you can bring these kinds of things into existence.
Mm-hmm.
Well, I am old enough to remember when this was tried, and but the thing is, you can't have a wholesale exchange, so it ends up being a couple of people a year from one office over to the other office. So you're not really accomplishing the change in the culture. It's not enough people to change the culture. And even as far as maybe you change one or two individuals, the downside is that both offices are very wary of having people from the other camp in their office.
That's true too.
Because they're going back.
Yeah.
So the idea of the defense attorney being in the prosecutor's office for 6 months or a year and learning more things to use against the prosecutor's office, it's not something the prosecutors like very well. And similarly, I remember some people in the exchange program, I didn't trust at all. I was wondering, what the hell are they doing in our office? You know, I don't want this person here. This person's got nothing to do with criminal defense. Whether we're going to play defense lawyer for a year, when they have no belief whatsoever in the rights of people. They're just here to as part of some, I'll play defense lawyer in an exchange program, and then whatever they learn, they take back to the other side. So I'm not the big a believer in the exchange program.
Could I add one other thing, though? There are a lot of things that prosecutors and defense attorneys can do as people who are recreating existing systems. And a lot of what goes on in big cities is actually redeveloping the systems or refining the systems or restructuring the systems. And if the prosecutor and the public defender actually cooperate at the policy level, I'm not talking about in the courtroom, because there it should remain adversarial. But if they cooperate at the policy level, there are enormous benefits to the entire system. And that's, I can tell you, half a dozen things that we've cooperated on in our county that have worked well. And I can tell you that we are encouraging other counties across the Commonwealth of Pennsylvania to develop the kind of policy level cooperation that we've developed in Philadelphia. And you know, just for a point, the District Attorney's Office in Philadelphia has been very, very cooperative at the policy level in the juvenile unit for the last several years.
Right. Right. George.
Any other questions?
You have one right.
I was wondering if you all believe that the Commonwealth of Philadelphia would have handled the Jenna 6 situation as an innocent prank, as the district attorney of Jenna, Louisiana did. Was it a situation that was caused by the South, by where it was at, the area, or do you think that it was caused by just their justice system? Would it have been different in Pennsylvania?
It's a good question. As a non-lawyer, I would say to you, and in a big city like Philadelphia, the media would have made tremendous difference. Tremendous difference. You got to keep in mind, this story broke on NPR about 3 weeks after it happened, maybe even longer. I published an African American weekly newspaper. I heard it on NPR on the radio driving to one of my 1,000 meetings a day. And then we did a story about it in our paper and some of the black press around the country. We kind of have our own internal network. And then it hit the general media. And then Al got hold of it. I'm talking about Reverend Al. And then this other idiot on the radio named Michael Bazin grabbed it and used it to propel himself into the public spotlight. It was all about him. It never has been about the kids. So you got to keep that in mind. This small town, it's about the size of this classroom. I talked to the NAACP president down in Louisiana, and Gina is so small that, for example, he urged us not to come to the demonstration on September 20th because there was no place to stay. So the 10, 15,000 people there, had to stay, hundreds of miles away because all the hotel rooms were closed and there was no place to communicate, even with telephones. So I think the media would have made a big difference. I think also because of the level of crime in the city, or in the city of Philadelphia or New York or Chicago, this would have been put so far down on the totem pole that it wouldn't have jumped out there. In my humble opinion, yes, the environment made a great deal of difference. This young prosecutor, I think, wanted to make a name for himself. And then in addition, you have probably the stupidest ex-governor in the history of any of the states in Blanco. I mean, remember, she's the same woman who didn't respond on the Katrina items. And then she doesn't even use the power of the Attorney General's, or even to ask him or her, I don't know if it's a man or a woman in that state to step in, because the Attorney General there could have stepped in and brought this thing to a conclusion.
I would just say that we actually did have a case like that in Philadelphia County. Lincoln High School, about, I guess, 6 or 7 years ago, there was a big fight in the cafeteria between the skinheads, white kids, and black kids. And as a result of that fight, there were several black kids that were arrested. During the time when we were going through getting discovery, we received the journal of one of the white kids that was involved. He was not only a skinhead, but he was a member of the Aryan Nation. He had a journal that had all kinds of racist literature in it and remarks and how he's going to kill all the black people in the school and about guns. And so what we did was, on the defense side, is we prepared some very large placards that we were going to use during the course of a trial. And since the public could be invited into the juvenile trial, it was our intention, and I was the lead attorney on the case, to invite the press in. And I certainly made the district attorney's office aware of it. And then very quietly on a Saturday morning, District Attorney Lynn Abraham dismissed the case. So we didn't end up having it actually litigated in Philadelphia County. However, I want you to remember that this is a very big state. There are, there are about 40,000 juvenile cases a year. And out in some of the rural areas of the state, there are cases like this that are going on all the time. I was up in Danville a month ago, and 3 young boys were about to be tried by an all-white jury for assaults against staff at Danville. And quite frankly, after talking to the judge, whose remark was that Danville is a very rural place. We have more cows than people from Montour County. We have more cows than people, and there are a lot of skinheads out here. That was the judge telling me that. And when the jury came in, the jury was about the size of the number of people here in this classroom, and they took up every seat in the courtroom, and there was not one person of color in the entire jury. And in fact, the judge told me he didn't know whether there were any people of color living in the county. So, and the boys have been in jail for a year, for an entire year, and they were about to go to trial. And I got together with their defense attorneys, who were very competent in some cases, others very inexperienced. And we worked something out so that we didn't have to go to trial on that matter. We still haven't resolved all the issues related to it, but I would say that you don't have to go to Louisiana to find these problems and issues. This is a very rural state, and there are rural states. The very large sections of all the states to the north have rural areas. Downstate Illinois, Michigan, north of Detroit. Ohio has a system where 90% of the kids waive the right to counsel for all their juvenile hearings, not just one county, but throughout the entire state. You have injustice going on a massive scale right next door to where we're practicing, or where you're going to school and where we're all going to be practicing. You don't have to go south. Go north, and you will find these problems. If you want to find out about the specifics, again, njdc.org, National Juvenile Defender Center.org, there are the evaluations there of these state systems. And the evaluations, they have a summary at the beginning. You can read all the summaries at the beginning of these evaluations. You'll find 16, 20 states that are just doing an abysmal job. Worse than what was described is going on down in Jena, Louisiana. And again, I've been down in Louisiana and evaluated that system, so I know that the system itself is flawed. And the system in Pennsylvania is flawed, getting better. And the system in Ohio is terrible. The system in Indiana was abysmal. You got locked up if you were truant, and they threw away the key. They didn't put you in a Department of Public Welfare facility. They put you in a jail where they held you, often without the benefit of counsel. So this is a widespread practice in America. We have been resting on our constitutional laurels for quite a while without the benefit of practices consistent with those constitutional mores. We don't have the right to counsel for kids. Kids are just getting slammed away. And believe me, you can just read these documents that I'm referring to, and you will see it all across the nation. It was happening in Baltimore. When they got their assessment, there was a complete overhaul of the entire juvenile justice system in terms of representing children. So we have problems all around us, folks. You don't have to go a long ways to find them. And there's plenty of room for all of you to have distinguished careers, either as prosecutors, or as defense attorneys, or public defenders, or as child advocates, or anywhere in the public interest sector. And again, I want to emphasize, a good prosecutor can have more influence on the system in many cases than a good defense attorney. So please, if you are contemplating that as a profession, do it honorably, do it well. Find out what you can do to make the system go well. And what George Mosey, who's the deputy in family court, tells me, he says, having a good defense attorney allows me to do my job with integrity. That's the first time I ever heard a prosecutor say that. Having a good defense attorney allows me to do my job with integrity. And that's what it means to be a good prosecutor. Do it with integrity, and you can have a tremendous impact.
Okay, I just want to make a brief comment. The fact that the DA in Jena characterized hanging 3 nooses under a tree and characterized it as a prank means one of two things. He didn't believe it was a prank, but he didn't care. Or he believed it was a prank, and then the entire culture that would allow him to believe that is poisoned. And we really need, not only in the court system, but in the educational system also, and in the arts, and in popular culture, ways to make it the case that a person, a DA, could not believe that hanging hanging nooses from a tree is conceivably anything like a prank. I'd like you to applaud our distinguished visitors for their wonderful. And I also want to invite you to a reception right outside here.
So it's supposed to be a clinic exists?
Well, it doesn't exist. We expunge records. I actually got a grant. And anybody who calls up, it's it costs $700 to $800 to have somebody do it. That's right. We expunge all records, even if it is representative.
Could I ask you guys to come forward?